In this video, I'll introduce the fourth principle of IDEA, placement in the least restrictive environment. You can find the videos on the first three principles of IDEA in the description section below. Least restrictive environment means that students with disabilities must be educated with children without disabilities to the maximum extent appropriate. For most students, least restrictive environment is general education with supplemental aids and services. For some students, the least restrictive environment will be a setting that is more restrictive, for example, self-contained special education classrooms. It is common that parents and school districts have different perceptions of the least restrictive environment for students. Understandably, many parents seek the best possible education for their children. They may consider the education offered by school district inadequate or only minimally appropriate. When parents disagree with the district's placement decision, they may challenge it by filing a due process complaint. How do courts decide the least restrictive environment? Since there is no national standard of the least restrictive environment, different federal courts apply different standards when determine whether challenged placement are in violation of IDEA's least restrictive environment. In general, the 11th Circuit, which has jurisdiction over federal cases originating in the states of Alabama, Florida, and Georgia, uses two questions to determine the least restrictive environment. The first question is whether education in general education classroom with supplementary aids and services can be achieved satisfactorily. The second question is whether school has integrated the students to the maximum extent appropriate. In the case Stamps v. Gwinnett County School District 2012, the 11th Circuit held that the programs developed by the school district were reasonably calculated to provide the children an adequate education in the least restrictive environment, and that the children were capable of attending public school. A doctor testified that the three siblings suffered from genetic and neurological disorders, and their immune deficiency did not require preventative treatment. They did not have a bona fide primary immune deficiency. Their immune systems would improve just like anybody with age, and the children had not been sick in several years. The doctor's testimony did not establish that three students had to be educated at home because they had a non-specific immune deficiency. The doctor's testimony was consistent with the opinion of an expert in pediatric infectious diseases. After reviewing the children's medical records and speaking briefly with the doctor, the expert concluded that the children would have the same probability of getting sick as other children, and that because they did not have any severe or unusual infections, they should not have any restriction on their socialization activities, be it school or going to community functions. Although the doctor stated that home tutoring had prevented the children from contracting illness, the doctor had not recommended that tutors follow any health protocols in the student's home, and the record established that the public schools would provide a more sterile environment for the children. In contrast to the students' parents, who disinfected only intermittently the areas of their home and materials used for teaching, the schools regularly cleaned the children's tools and workspaces between teaching sessions. The district placed each child in a school that could accommodate his or her specific needs for hygiene and level of disability, and the executive director of special education for the district testified that if the children became ill, they would receive intermittent homebound instruction. The court ruled that the school district's proposed in-school placement rather than homebound instruction for 3 siblings with genetic neurological disorders met substantive standard for FAPE in the least restrictive environment. Here is a recent case about least restrictive environment during the COVID-19 pandemic. In this case, the school board approved an updated health and safety plan which mandated universal masking indoors, though it remained optional outdoors. The parents of children with disabilities filed a complaint on January 21, 2022, arguing that the optional masking discriminates against their disabled children because it has the effect of excluding these students from their public institution or otherwise denying them the opportunity to participate in the services of the school district. Even though the parents' complaint used the phrase least restrictive environment, this case at its core is about the parents' alleged inability to access on-site school learning due to the optional masking policy. Since the challenged optional masking policy did not have an impact on the students' access to the curriculum, and the parent did not challenge the substantive quality of education, the district court concluded that it's not a FAPE-based claim. In this video, I introduce the 4th principle of IDEA, placement in the least restrictive environment. The next video is about the 5th principle of IDEA, related services and supplemental aids.